That was my first and last mistake. I'm blue without your face. But what can I do? 'Cause I'm just a sinking ship, and you're just a pair of lips that I've lost in the moment. All I want is for you to come back. Now I'm caught in the middle of life, and I need you to survive. Whoa, I need you to survive. 'Cause without you by my side, I can't survive.
All right. All right. All right. How's everybody doing? My name is 12 Gauge. Welcome to my channel. This is your first time here. I hope that you find something that interests you, something that gives you a little bit of understanding about true crime. You know, I was presenting some things earlier on upload that somebody said that was kind of, I don't know, graphic, I guess they were saying. You know, because I was talking about the stabbings and not really stabbing, but about knife wounds and, you know, how certain things interact within what happens whenever you get a knife slice or whatever. Um, I do want to give you a disclaimer. This is a true crime channel, and there's going to be some things that you hear or that you see that are not always that I guess in the etiquette world having coos. So please be advised that, you know, my channel is a little bit edgy and it does talk about true crime and it shows some examples and it gives some maybe some readings that maybe you're not accustomed to. And, you know, like I've told people before, if some of the content is not your flavor or your cup of tea, then it's okay if you don't stay. You know, I understand it. There are, you know, some things that I present that are not they're not too people friendly, you know. Hello, Aquarius. Thank you for being here. You know, my intent is not to harm anybody or to give them any kind of situation that trigger any emotional issue that they might be having for themselves, you know. That's why I try to keep um a chat that is very um people orientated, where it's not about, you know, bickering and arguing and things like that. Because I do understand that people can be triggered. You know, they can have situations in their lives um that do have them not feeling their greatest. Hey Kim, how are you doing? I've had so many Kims in here in the uploads and everything. This is typically unique Kim. The other Kim was a different Kim that I was discussing in my uploads. The uploads are not that bad, but I do enjoy interacting with people in the chat, because they do offer some insight. Um, they offer some different perspectives that I might not see or might not understand for myself. Honestly, I was waiting on some football, and I guess they're gonna reschedule it or something. I don't know. Um, wow. Let me put that up there, Kim. I had a soft A lockdown at school today. I freaked because I heard lockers banging. Oh no. Oh no. Would you like to come up? Can you come up? Because my topic tonight is dealing with schools, and um, I wanted to present something where I could get a different perspective on maybe helping parents or any suggestions for, the possible trying to assist and trying to curtail this phenomenon that's going on regarding active shooters at schools, or maybe some things that you've learned at your school district that maybe you could pass along to the viewers. If only your voice, you don't have to be on panel with your face or anything. I mean, if you choose to, that'd be fine, but that kind of goes along with what I'm talking about tonight, because I'm going to continue talking about the the Uvalde shooting, but I'm going to take it in a different direction tonight. I found a video that discussed a mother that ran in to get her children, and I thought, wow, this is something that really needs to be shown, because there was um, not a lot of things shown that day about heroism, people going above and beyond being heroes. And it's a very interesting topic because there's so much. It's like yearly, it seems like um this is a topic that is needed to be spoken on. I don't know what could change regarding the shootings or the education. I don't know what y'all do as far as educating your students. I don't, I'd like to know though. I mean, that's one of the reasons I'd like to have you on panel, is to give a firsthand perspective on some of the things that you guys talk about when it comes to school shootings, or, as far as the understanding. But let me go ahead and play this video while I wait for Kim to give me her answer on wanting to come up or not. Because last night I was talking about Uvalde here in Texas. Um, and this gives you a different perspective from a mother's point of view. I thought it was pretty awesome. Let's listen to it.
So we are hearing this morning from a mother who ran inside the school in Uvalde, Texas to protect her kids. She says that police held her back and handcuffed her as the shooting unfolded. Lilia Luciano has the exclusive interview. Lilia, good morning.
Good morning to you, Anne Marie, and to Vlad. I met with Angeli Gomez yesterday in a field nearby. She's a farm worker. She was telling me that her kids, on the morning of the shooting, had both graduation ceremonies, or a ceremony at school. She showed up there, but she didn't want to take photos with them. She told me she was embarrassed because she had come straight from work. She was working early that morning, and she was dusty from the field, but her kids told her, "Mom, we want to take this photo." She says, I'm so glad I took that photo, because it could have been the last one. And it was for many of the parents who lost their children who had been there. Like many parents, after that, she left, she went back to work, back to the field. And within 10 minutes, she received a frantic call from her mom telling her that there was a shooting at the school. So she got in her car and she sped at about 100 miles an hour, she told me, until she finally got here. And this is what she told me after.
I know this has been a while, but I believe that you can never play this enough, because this event right here would just, it rocked a lot of the situation that have become active shooters. It has shown how one person's determination with a weapon can do so much damage. And can you imagine going and taking pictures with your children, leaving them, and then going back because you heard there's an active shooter?
Right away, as I parked, U.S. Marshals started coming toward my car saying that I wasn't allowed to be parked there. And he said, well, we're going to have to arrest you because you're being very uncooperative. I said, well, you're going to have to arrest me because I'm going in there. And I'm telling you right now, I don't see none of y'all in there. Y'all are standing with snipers and y'all are far away. If y'all don't go in there, I'm going in there. He immediately put me in cuffs.
She says after Uvalde police officers told marshals to uncuff Gomez, she ran towards the school.
As soon as they uncuffed me, I jumped that first gate fence. And once I jumped it, I went to my son's class and I knocked on the door. And I remember the teacher saying, I'm like, hey, they're already bulge cutting the fence to get me. She's like, you think we have time to get out? I said, y'all have time. I'm going to run for my other son.
Once she was assured her son was okay, Gomez ran to get her other child, encountering more officers who tried to stop her.
So I start yelling and I'm being uncooperative and I'm like, well, y'all aren't doing what are y'all doing? Y'all ain't doing y'all need to be in here. Give me your vest. Somebody give me a vest, something. I started paying attention to how far the shots were being, so that I knew the shooter was all the way still by my first son's class. So when I went to my...
Welcome, Kim. Thank you for hopping up on panel. I'm playing this video that this mom is giving her firsthand recollection of what she did the day of the shooting, and it's pretty powerful to listen to. How are you tonight?
Hi, I'm good. Can you hear me okay?
Yes, I can.
Okay. Yeah, I have watched that video, that mother, so many times. I mean, I can imagine and relate to how she feels.
Yeah.
She was real to me.
I can't believe, the police trying to, I mean, I understand both sides, okay? I get the law enforcement side. You don't want people running in there and putting themselves at harm's risk. But at the same time, that's her right. That's her right to want to go in there and grab her children, wouldn't you say?
Oh yeah. Yeah. And when they're preparing for how to handle these situations, managing the parents that are going to show up on scene is a huge part of that.
Mm-hmm. Yeah.
I know in our school district, they have a plan to use city management, like waste trucks and all city vehicles that wouldn't be used, snow plows, things like that. They plan to like block off the roads to try to limit the traffic.
Oh, wow.
Mm-hmm.
Well, let's keep watching this a little bit more, and then we'll discuss some things that maybe she says, maybe some things that you know about this, Kate, that I'm not too versed in, and about your school district, if you don't mind.
Sure.
My second son's door, the teacher didn't want to open the door for me. So that's when they started escorting me out. And as I see that they're opening my son's door, I go run for my son and I get him.
With both of her kids out safe, Gomez still can't shake the thought of those who didn't make it. While you were inside the school, did you see officers
There was
inside
not one
the school?
officer inside the school when I
In
ran
the
to my
areas-
second son's class. There was not one officer.
And you were hearing gunshots, so you knew
You
that
could hear the
it was an
gunshots.
active
It was
shooter.
still active. The gunshots were still active. They were not in there. There was no one in there. If anything, when I pulled up, my car was closer to the school than where the snipers and everybody that was laying on the ground were.
When you heard that it took law enforcement 75 minutes before they went in and stopped the shooter, what was your thinking, having been inside the school yourself?
I don't know. I was just thinking that they could have saved many more lives. They could have gone into that classroom and maybe 2 or 3 would have been gone, but they could have saved a whole more, the whole class. They could have done something, gone through the window, sniped them through the window. I mean, something, but nothing was being done. If anything, they were being more aggressive on us parents that were willing to go in there. And like I told one of the officers, I don't need you to protect me. Get away from me. I don't need your protection. If anything, I need you to go in there with me to go protect my kids. And if anything, they were being more aggressive on us. They were more pertaining on keeping us back than getting into that school.
That's horrible. That is horrible. To sit there and have that feeling that you're trying to get to your child and these people are keeping you from it. And they're unwilling to even go and risk their own lives, as we later found out.
Yeah, did you see the videos of how long it took for them to actually go down by the room?
Yes, yes. I showed a little bit of that last night.
Yeah,
And
that
it
made me
was
sick.
and it was so, I mean, when I've watched it a couple times myself, and just hear the gunshots, and then to know that these policemen were capable of stopping that rampage, and they just kind of waited around. It made me sick as well.
Yeah.
Just terrible.
I went
You know,
up
this
to,
is
oh, sorry.
Go ahead.
That's okay. I just wanted to say, after this happened, I went up to our resource officer, and I know him. Like, I grew up with him, and I was like, if something happens, you're coming, right? You're coming in. And he like promised me up and down, yes, yes, we're coming.
Yeah, because that was one thing that I was pointing out last night. Because I did a little bit about this last night, and the resource officer that was supposed to go in, he waited outside. Even after the police came, he still didn't go in there. And
Yep,
that's terrible.
yep. Yeah, because we depend on them.
her account is another reflection of just the gaps in communication, those holes that we're trying to fill about the information that was coming in from 911, what the officers outside knew, what the officers inside knew. We know that there were officers inside. That's what law enforcement, Texas Department of Public Safety have told us, that there were officers outside of the classroom in a different area, clearly from where she was. But, it's the frustration of the parents trying to get in is something that's understandable. And of course, law enforcement can't just let all the parents go in when there's a shooter inside, clearly. But her energy, her frustration is what's reverberating across this community at this point. And she also told me that, she's on probation for some charges from about a decade ago, and that she received a call from someone in law enforcement telling her that if she keeps talking to media, or if she, keeps sharing her story, that she might face some kind of violation for obstruction of justice. So she was holding back from sharing her story until now, because a judge told her that she was brave and that her probation would be shortened. So that gave her the courage to talk to us. Her uncle's the one who called me and said, you have to hear her story. And I'm so glad he did. And I'm so glad we also met her in the field. She told me, for me, it's important that you come here and you see how hard we work in this heat under the sun. And by the way, there was another parent whose story I'll be sharing later, who lost his son and was still there at work under the sun.
Wow.
Lilia, I'm also happy that you were able to file the story with the amount of time that you devoted to sharing Anjali's story, the amount of time that you allowed her narrative to breathe, as we say in the business, to just allow her to express herself, because it is a vivid description of what happened from one parent's perspective on that horrible day. And I just keep going back to what she told you about the police officers who were parked further away than where she was parked, and who ultimately tried to handcuff this mom who was willing to brave whatever, whether she was going to be shot by the shooter or be arrested by police officers. She wanted to go in there and get her children, which is absolutely natural, which just brings into sharp focus the inability or the inaction, I should say, of the police on the scene.
Yeah. And we've heard that same sentiment from many parents. She was detained, she told us, by marshals, but the local Uvalde police who are familiar with her and know her were the ones to tell the marshals, let her go. We know her. She's a mom in the school. So that's who, got her, I guess, released from the handcuffs. And instead of turning back, she said, all right, this is my chance. And she went in there. It's a call that I think a lot of parents wish that they had had the opportunity to make.
Well, to sort of reiterate what Vlad said, the other thing that you get out of this story is just how sort of disorganized everything was in terms of the police response there, that she was able to run in even after being told not to. And so that, of course, brings us to the police chief, Pete Arredondo, who's been taking a lot of heat about the decisions and choices he made. Initially, we had heard that he had stopped cooperating. Now, his people say, no, he's still cooperating. Do we know what's going on with him?
Yeah, he himself told our Houston affiliate KHOU yesterday that he has in fact been in communication with DPS every day. We've been trying to reach him. We've, shown up to his house. We've shown up to his work. We're trying to get an interview with him. I actually yesterday stopped someone thinking it was him and it wasn't him. And he's like, no, I'm not Arredondo. We just look alike. Everybody's trying to get answers from him. Of course, he says he's been talking to DPS, but DPS tells us that at least to the Rangers who are a part of DPS and the ones running the investigation, he hadn't responded to requests for interviews, for follow-up interviews. He did those initial interviews. But today and yesterday, I've also been talking to State Senator Roland Gutierrez. He says, look, we keep hearing Chief Arredondo's name, Chief Arredondo. He just oversaw the school district police. That is a tiny body just overseeing the schools. And yes, clearly he made the wrong call, but it's also unfair to put everything on him when you had so many, you had state law enforcement, you had border law enforcement, you had local city law enforcement. How come none of those agencies said, you know what? No, there's an active shooter, or we're not sure that whether there are still people in there to save, we're just going to go in like the Border Patrol, not Borstar, that's the other one, BORTEC, a tactical team went in there and eventually, shot the shooter. That's a question that Roland Gutierrez, a state senator, is asking DPS. He's demanding a report, which he will share with us, and we're also demanding to know exactly who were the officers that were inside the school, where was every agency represented, and understand that, who else could have made that call differently and taken charge.
So we are hearing.
All right. Sorry about that. Are you still there?
Oh yeah, I'm here.
Okay. Well, watching that like you did, what did you think about that?
Oh, I have so many thoughts. How long it took for them, because eventually a team of people did say, F this, we're going in. We don't care who's in charge. We're going, and that's what ultimately led to them getting the guy. And it's sick how long that person was in that room. And I remember them describing, because it was 2 connected rooms, I believe, and he kept walking back and forth to each room. I mean, he had so much time in there, and you just think, like, if they would have acted so much faster, the kids that were injured could have been saved. It could have ended sooner. I mean, there's that part of it. And then I believe that Arredondo guy, I think he got fired, didn't he?
Yeah, I think so too.
Yeah. And I watched, I don't know if they were city council meetings. They were some kind of public hearings that they had, and the community showed up, and those parents, oh my goodness, I'm sure, I don't know if it's on YouTube or not, but I watched those, and those parents did not hold back, and they went there meeting after meeting after meeting, just demanding. I think it was mostly about the resource officer, because they just put him on like paid leave or something, and they were just really fired up over that.
Yeah, you're right about that. it's sad. So many years have gone by, and this is still fresh in people's minds. People are still here in Texas, anyways. You hear about it all the time. You know.
Yeah, that was that was a really tragic one. The way it was handled, like it's a school event like that is tragic enough, but the way that was handled, that one in particular, just oh man, that was so bad.
So, can you very briefly just tell us about the safety procedures y'all have going on at your school or your school district?
Well, I have to tell you, I feel like we probably have the safest schools in the country. That's the way I feel. Um, we have, of course, all the doors are locked. Everybody has to key card in and out. Nobody can get in. Parents can't even come in. They have to buzz. They have to tell the secretary why they're there. They have to wait. We don't even let them in the office. We have like a little vestibule area, and then we make them wait in there. And we have, that button that they were talking about with the Georgia event.
Yeah. Yes.
We've had that for 2 years. We got them at the
Right.
beginning, well, a whole school year. We had it they gave them to us last school year. And when you hit that thing, it notifies the police. It locks, like all of our hallways in our building have fire doors, they call them. So
Okay.
they're normally open, right? But if there's a fire, they will trigger the doors to shut, and this button will shut them. And if you're in that hallway and those doors shut, you're trapped. So
Right.
at least it would confine the event and for responders to get there. And if you have a master key, you can get in there. We have an anchor man, they call it, and it's a bolt. So all of our doors, our classroom doors, have a plate at the bottom of the door. It's only about, I don't know, 4 inches wide,
Mm-hmm.
and there's a hole in the floor, and you have a little, so that part's attached to the door, the plate. And then you have this piece that slides into it. It's on a spring, and you stomp on it, and the bolt goes into the floor. So nobody's breaking through that. Like
Right.
they said a battering ram can't even get through that.
Well, that's great. That's
Yeah.
great. Yeah.
Yeah, we have a lot. And this school year, every year, I don't know where our operations manager comes up with this money, but he adds safety features every single year. And this year they put a special coating on our glass windows and doors um, that are, bulletproof.
Do you feel like this should be happening to this extreme? Or do you feel like, well, this is the world in which we live in today?
For these protections,
Yes.
oh, I feel like they're necessary. Like they give me peace of mind.
Okay. Okay.
Yeah, because I mean, look at how you never know. You just never know. We had an instance a few years ago where someone brought a BB gun to school and they hid it in a ceiling tile, like in the bathroom. Like, these kids, I don't know.
Well, some new document just dropped. Do you mind if I shift gears a little bit?
Sure, sure. Oh, is it the change of venue?
No, these are
Oh.
different. They'd almost look like motion to suppress.
Oh.
It started with the motion. Here, there's a bunch of them. Let's see right here. Expert witness disclosure, motion and memorandum in support of motion to trifurcate the proceedings and apply rules of evidence, motion for court order, motion to strike the felony murder aggravator, motion to strike future dangerousness aggravator, motion to strike HAC aggravator, motion to strike multiple victims aggravator, motion to strike notice of intent to seek the death penalty, failure to present aggravators, motion to strike notice of intent to seek the death penalty, vagueness, motion to strike notice of intent to seek the death penalty, contemporary standards of decency, motion to strike notice the intent to seek the death penalty, international law, motion to strike state notice pursuant to JC 18404A on grounds of arbitrariness, motion to strike the death penalty, and motion to strike utter disregard aggravator. So I want to start with the first one, if you don't mind sticking around and kind of giving me your thoughts on this as well. Are you there?
Yeah. I probably got about 10 more minutes.
Okay, cool.
Just because it's a school night.
Well, I understand that. I shouldn't have started just so late, but anyways, I was gonna watch football. I'm not a documents professional, so don't hold me to knowing everything that this says, but I'm pretty intelligent, so hopefully we can figure it out and exactly, understand it and not spread any kind of speculation. So it says state of Ohio, or yeah, they're messed up already. State of Idaho versus Brian C. Koberger. This is the motion to strike felony murder aggravator. Come now, Brian C. Koberger, by and through his attorneys of record, hereby move to strike the felony murder aggravator from the state notice pursuant to Idaho Code 19-404A. The motion is made on the ground that a malice aforethought murder cannot be aggravated by a burglary that itself is predicated on the same murder. So a motion to strike is basically that's what it is. They're looking to strike this motion, and these are the issues that they have against that. They have against what I said, felony murder aggravator. So these are some of the issues. Whether felony murder can be predicated on a burglary itself, predicated on murder. Whether malice aforethought murder can be aggravated by a burglary predicated on the same murder. So he did get felony murder charge, right?
Right.
Yeah. So this is a motion that it's kind of challenging where he could commit in my understanding, whether he could commit a burglary on the same murder. You get what I'm saying? Like you're charging him with felony murder, but how did he commit a burglary with that charge?
I thought that was automatic. Like, I thought that was like a little added thing they can just automatically, because you're assuming he's in there. Anytime you enter a residence without permission, I think they can call it that.
That's what I thought too, because I've had questions about that from the very beginning. I've
Yeah.
even asked people, how the hell did they get him for burglary? He didn't take anything that we know of. You know what I mean?
I think it's just going into the house.
Yeah. So here it says felony murder cannot be predicated on a burglary predicated on murder. It is impossible to change or to charge felony murder on the basis of a burglary with the intent to commit the murder in question. The state is given notice that it intends to show the murders in this case are aggravated because the murder was committed in the perpetration or attempted perpetration of a burglary, and the defendant killed, intended a killing, or acted with reckless indifference to human life. In count one, the state charges that Mr. Koberger committed burglary by entering a residence. Very good, Kim. Very good.
Yeah, I got one.
Yes. Very good. Very good. Did you already read this?
It's just my true crime experience.
All right. All right. Carlos taught you that, right?
Yeah.
Okay. It said In count one, the state charges that Mr. Koberger committed burglary by entering a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder. Count 3 through 5 all charge premeditated murder. So they're charging it as a premeditated murder, meaning that he had planned this murder somehow. Isn't that what premeditated means to you?
Yeah, planned out.
In other words, the state seeks to prove the aggravated circumstances of this murder by showing intent to commit murder at the time of entry. So then it goes into the cases where they were, some of this has been fought out in the courts and how they get to the point of where they're at today. It says there is no rational reason for a first degree intentional murder to be enhanced by the fact that the murderer intended the killing at the time he or she entered a building. And then it states, and then it goes into the litigation parts of different court cases. And then it goes right here, it says, according to the court held that holding on this issue makes sense because without the robbery, the state would have received only a second degree murder conviction against Sivak, and this is one of the cases, and with it, a much lighter punishment. However, because of the robbery, the state saw and received a first degree murder conviction carrying a more severe penalty. Thus, Sivak, in essence, is being punished for the robbery by the way of the punishment he received for the felony murder offense.
I don't know. That whole thing seems convoluted. I don't because I get if you can charge it by going into the house, then I don't understand what her argument is. Yeah, it makes the punishment worse. I think that's the whole point of charging it.
Right. I think they're trying to get the point that if we can show that he didn't intend, well, this shows like this is written by the state because it's the state of Texas versus Brian Koberger, right? So the state is trying to prove that, I guess they're trying to enhance this based on the fact that he premeditated the murders, according to them.
Oh, this is not from the defense?
No. It says,
okay.
It said William burglarized the Charles home with intent of murdering Mason. The murder was not committed to carry out the commission of the burglary. Had this purpose been to steal jewelry, and Mason was killed to facilitate his thievery, a case for felony murder would exist. Here, however, the sole purpose of the burglary was to murder his victim. It just so happened she was in a place he was not permitted to enter. Thus, the murder, although in the course of the burglary, was not carried out in furtherance of it. So that's basically saying that this person went in to kill this person, but while they were doing it, they stole the jewelry. So, that's where the burglary part comes from.
Right, and it sounds like she's asking remove the burglary because if it's just to go in and do the deed, then it's just to go in and do the deed.
Right. And I don't understand well, I can see because I had a question on that from the very beginning when they gave the burglary. I thought, well, what did he take with him? Why,
Right.
just entering the residence, I see your point now. But at the same time, what would it be that they're trying to get that? I guess they're trying to get as many charges off there so
Right.
they can drop it down from the death penalty. It looks like by those other motions.
Yeah.
I bet you they
gonna
end
fight
up
everything.
pleading out. I bet they end up pleading out.
You think?
I don't know. Like some of these are asking, for notice of intent, like to strike the notice of intent for the for the death penalty based on vagueness, failure to present aggravators. So if this is the stuff that the state failed to turn over, this would make sense that that's why they're asking to strike this. Like if they didn't turn over any of this stuff, like to the evidence that of discovery that they were waiting on, if that evidence somehow precipitates the evidence they have already, then they're going to try to strike the evidence that they have against them based on the incomplete evidence of the whole thing. Does that make sense? Like I said, I'm not a document person. I'm not a document expert or anything, so don't hold me to it. But that's just kind of like what it looks like.
I think she seems very methodical. She
Yeah,
seems like she knows step one, step two, step three. So this seems like, yeah, she's trying to knock
yeah,
everything down to to lessen the charges at this point. That's what all that seems like.
right. And it said here, thus, under Idaho law, felony murder could not be based upon a burglary whose sole aim is murder. If that is so, the question is whether a deliberate intentional murder with malice aforethought can be aggravated by a burglary predicated on the murder itself. That just doesn't, I mean, I understand the concept, but I don't understand what they're trying to ask.
It's a
It's
bunch
like,
of jargon. I don't
well,
know.
here's another case. It says the court considered whether a man charged with killing his wife's murder could be aggravated because he entered his house to do it. The court began by considering the nature of the burglary and finding it is an aggravated trespass, a trespass with the intent to commit a different crime. Then the court noted that to reach capital murder, a murder must be intentional and have an aggravating factor. The court then found that a situation where the burglary is predicated on the murder intended is not adding anything to the murder. The court then considered the common law basis of felony murder and how it diverges from its use in the capital arena. So,
Do you think she's working backwards? I mean, because she's saying she has said he's innocent. So if she's saying he didn't do it at all, then it's definitely not premeditated. And then so you can't have this burglary charge. So is she starting with the least offense and then gonna work backwards from that? I don't know.
it said this court should hold that Idaho had the same understanding of its aggravation. I need to go back to school and learn to read. Aggravation statute
I have to teach that stuff.
for this court to rule otherwise, it would have to overrule Cybeck, which it cannot do. Therefore, this court must excise the felony murder aggravator from the state notice. So it's saying that they need to strike that. And based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the felony murder aggravator in the state notice pursuant of Idaho Code 18-400 be struck. The court not instruct the jury on the felony murder aggravator. So they're looking for this to be taken out. Who's Jay
Yeah.
Logston? Jay Logston is
He's one of the attorneys. Yeah.
he's Koberger's attorney, right?
Yeah.
So that's that one. Okay. So if any of y'all are more proficient in document reading, if you'd share with your peers in the chat what this kind of means to you, that'd be great. Maybe we all can learn a little something tonight. Because like I said, I'm not a document Guru by no means. And here's another one. I'm just showing you the documents, and then you're like, well, why are you showing us if you can't if you can't tell us what it says? Well, wouldn't you want to see them? Can you dig it, Kim? Can you dig it?
I can dig it, and we can talk through them.
Okay, this one says motion for court order requiring the state to provide notice of every alleged non-statutory aggravating fact, circumstance it may rely on at the sentencing trial, and to prove beyond a reasonable doubt every alleged non-statutory aggravating fact or circumstance. So that's basically ordering or requiring the state to provide notice of the aggravating facts or circumstances that they're going to rely on during the sentencing part. It says, comes now Brian C. Koberger, by and thorough his attorneys of record, and hereby moves to this court for an order requiring that the prosecution provide the defense with notice of any non-statutory aggravating fact or circumstances it intends to prove at the sentencing phase, if any sentencing phase is conducted, and that prosecution be required to prove any such non-statutory aggravating circumstance or fact beyond a reasonable doubt to the unanimous satisfaction of the jury before any juror may consider an alleged aggravating fact or circumstance as a reason to support a death sentence. So this is basically wanting the state to provide
Mhm.
their facts.
Yeah, it's like she's calling them to the carpet. Like, what do you it seems like she's saying, what do you have that is going to prove that?
Right. Exactly. Like once if we get to the sentencing stage of the trial, whether it be guilt, we want you to know ahead of time that we want you to provide
Mhm.
the alleged aggravating facts or circumstances as a reason to support the death sentence. Because I guess they're setting it up just in case he is found guilty. They want the state to be able to prove the aggravating portions of why they went after the death penalty.
Yeah, that's what it sounds like to me. I mean, I don't really fully understand it either, but
It said, let me read a case. It said in State versus Hall, the Idaho Supreme Court held for the first time that evidence of non-statutory aggravating circumstances is admissible in the capital sentencing process, and that it may be considered by the jury in determining whether to sentence an individual to death or life imprisonment. So there we go. Where it's getting to that portion that I'm moving towards if he is found guilty. This is setting it up that you need to prove to us there was some aggravated stuff, evidence that gave you the inclination to go after the death penalty versus life imprisonment. It says Mr. Koberger has argued elsewhere that Idaho's capital sentencing scheme, as articulated in Hall, is unconstitutional due to its arbitrary nature. Mr. Koberger maintains those arguments here. However, the court disagrees and holds that non-statutory aggravating circumstance evidence would be admissible at any potential sentencing phase in Mr. Koberger's case, then the court must enter an order requiring the prosecution to provide him with sufficient notice of any non-statutory aggravating fact or circumstance it intends to introduce and to rely upon during the sentencing phase, should one be held. Such notice is required by the due process and the cruel and unusual punishment clauses of the United States and Idaho Constitution.
I think she's just calling him out for more evidence.
Yeah.
I think she's just saying this is just one more thing that, and she probably wants to go into trial with that off the table, with the death penalty off the table.
Well, once I mean, they're getting to the portion of the process where they're going to start doing the suppression hearings. So maybe these are motions ahead of time for suppression. These are some of the things that they're going to want taken off the table. That could be wrong.
Were some of the other documents about suppression? Because there
Well,
was a lot. You read a
their
lot of them.
motion to strike.
Oh, strike. Okay.
Yeah, like take
Like just
take
get it
totally
out.
off. Yes.
She came out big.
Yeah, like not
Yeah.
suppress. I mean, suppress basically means the same thing. You know, we want to take
Right.
it. We want to take it off the table. We want it off the record. You know.
Right. Hmm.
So that's that one, and it says this is what it says. It says failure to require the prosecution to provide the defense with sufficient notice of any evidence of non-statutory aggravating facts or circumstances it intend to introduce at the sentencing phase would be a blatant violation of Mr. Koberger's 8th and 14th Amendment rights under the Langford and Gardner, as well as his rights under Article 1, Section 6 and 13 of the Idaho Constitution. So this is basically setting it up to say, if you fail to do this, then you have violated his 8th and 14th Amendment rights, and it's in writing. So therefore, that would be a motion for appeal.
Right.
So if he is found guilty and they fail to do this, because for some reason individuals think that there's a secrecy going on whenever they're setting up for the trial or during the trial or after the trial, but it's not secrecy at all. That's one of the things about the justice system is that they're giving the notice, hey, if you fail to do this, this is the consequence. So if the state is willing to gamble on that, then that's part of what they might appeal on, because they've given you that notice. And that's usually how, you know, um, how the state works. I mean, you're a state employee, right?
Yeah. Hmm.
Being a teacher.
Yep.
So during any of your trainings, don't they always break it down to these are the new things we want?
Oh my
Failure,
God.
failure to do this will
You
get you
have
this,
no
this, and
idea.
this. Yes. So it's the same thing here, basically on these um
Right.
on these documents. Is they're giving the prosecution so much and saying, well, if you fail to do this, we already notified you. And that's what I'm telling you as far as yours, because I work for the state too. And there's always subheaders that tell you, hey, if you fail to do this, it could cause a write-up, it could cause, 3-day suspension, it could cause
Yeah.
termination up until, this, that, and the other. So let
Yep.
me read what it says. It says failure to require the state to provide such notice to Mr. Koberger in his defense would also violate the Sixth Amendment and Article 2, Section 13 of the Idaho Constitution because counsel cannot effectively engage in an adversarial process without pretrial access to such information. So that's saying that they can't go advocate for their client without this this stuff that showed aggravating. Now I forgot what the hell it said, but aggravating.
The aggravating circumstances, I think.
Yes, aggravating circumstances. There it is. Okay. Okay, let's continue on. It says not only must Mr. You got to go.
No, I was gonna say I still just think it's just like her continuing to ask for evidence. All the
Yeah.
evidence that I don't know they haven't turned over. Everybody's like, "Where's it at? What do they got? What are they holding back?" It just seems like it goes along with that to
Well,
me.
it's interesting to me that they're talking about the sentencing right here. Like, this is way, I don't know if it's normal to go through the sentencing part right now before the suppression. I don't know. I mean, I haven't gotten to that portion yet, or if I have, I didn't read that chapter very thorough, obviously. It
No,
says not
I
only,
agree with that too. That sorry, I didn't. You can read,
go
but
ahead.
I agree with that too. Like it's odd that they're jumping that far. Like she's jumping to that. So I understand you thinking that maybe or is she going to plea or
Right.
even
It
though
says,
I don't think that personally, but I understand that.
well, I mean, I guess we say CYA, cover your,
Yes, yes,
you
exactly.
know, so you got to cover your rear, because you have to say, well, we already gave you this. That way you can't come back and say, well, you never filed this or you never let us know this.
Yep,
It says
yep.
not only must Mr. Koberger be able to adequately defend his life at sentencing, but this court must carefully screen each evidence in advance for admissibility. There it is. The court can only do so if it requires the prosecution to provide the defense with advance notice of non-statutory aggravating facts or circumstance evidence which will enable the parties to engage in important pretrial litigation concerning the admissibility or reliability of any such evidence. Okay, there it was, right there. So that's basically what this one is saying, that they want the evidence of the aggravating circumstance before the sentencing stage of the trial. There's a lot. Look at that. I mean, that's what I've had to go through this whole probably 2 semesters ago. I had to read all that stuff, and I mean, as you can tell, I read it, but not very proficient in it. Let's talk about the intent to strike the notion of the death penalty. This is the next one in line.
Okay.
Mind the monsters, you want to come up?
I can tag you in because I gotta go get some sleep.
Heather says motion to strike death penalty is complementary to motions in limine. This is when
I,
I need you. This is when I need Heather to come up so she could explain this stuff. But
come up,
no,
Heather.
come on, Heather.
Come on, Heather. I am gonna jump down though. I might be in chat for a little bit, but that's because
All
I'm
right, that's cool.
walking around my house. But thanks for having me up.
Hey, no problem. Thank you so much.
All right, have a good night.
You too.
Bye.
Bye. I don't know why I put that up there. Well, I can't read this and read the chat at the same time, so let me give that link again so she can come up. Either one of them. That way they can help me with this because I'm not claiming to be an expert or very proficient. This is my limitation. There's the link if you want to come up. Mind the Monsters or Heather, either one of y'all. I'm going to continue to read it. This says State of Idaho versus Brian Koberger, motion to strike the notice of intent to seek the death penalty on grounds of failure to present aggravators to neutral fact finder. Of course, it starts out with the same thing. Brian C. Koberger, through his attorneys of record, hereby moved to strike the state's notice pursuant to Idaho Code 19-400 on the grounds that there was no check on the decision of the prosecutor to pursue the death penalty. This motion is based on the 5th, 8th, and 14th Amendments of the Constitution of the United States and Article 1, Section 6 and 13 of the Idaho Constitution. So the right to a fair trial. The Constitution requires a neutral fact under the fact finder to determine whether the death penalty may be pursued. The process provided to Mr. Koberger up to this point has failed to adequately protect him from being arbitrarily selected for the death penalty in violation of the 8th and 14th Amendments, and that no check was placed on the discretion of the prosecutor. The prosecutor has previously told the court what the state is trying to do is to enforce the law that our legislature has put in place that says in cases such as this, in facts like this, a jury is entitled to decide not only guilt but potential penalty. We're simply trying to fulfill our responsibilities under the law. To characterize it as state is trying, is wanting, is trying to kill someone, is just simply appealing to raw emotion, and it has no place in the courtroom. So this is what was stated in the courtroom on one of the hearings. However, as the prosecutor knows from his own experience in refusing to pursue the death penalty, in the State versus Lee, the decision to pursue the death penalty falls entirely and unreservedly to his own personal decisions. In Idaho, the decision to pursue the death penalty is the prosecutor's. LC 18-404 provides the penalty for first-degree murder is death or life imprisonment, but it may only be death where the prosecutor files notice of their intent to pursue death. 18-4004A provides the prosecutor may drop the pursuit of the death penalty at any time, and if they do so, death cannot be the outcome of a case. So at any time that the prosecution feels that their case doesn't have the adequate evidence or case to go any further, they can drop the death penalty if they so wish. And we've seen other cases where this has happened. The only limitation of the prosecutor's ability to seek the death penalty then it is when is that it to be a first degree murder case, and that the prosecutor can find one circumstance of the case called a statutory aggravator. That's what we just talked about a while ago. As explained in detail in Professor Cover's Narrowing Death Eligibility in Idaho, an empirical and constitutional analysis, Idaho L. Reverence 559, 2022, due to the brand and vague nature of both, what constitutes murder and what constitutes an aggravator, almost every murder is eligible for the death penalty in law. Professor Cover and her team analyzed first and second degree murder cases in Idaho filed between June 2002 and the end of 2019. They found that 86 to 90% of all murder convictions were factually first degree murder cases, and that 93 to 98% of those factually first degree murder cases were eligible for the death penalty under Idaho's scheme. In fact, the scope of Idaho's death penalty is constitutionally defective in its own right, as it will be argued in the separate motion. Thus, there is no jury entitlement to the death penalty. There is only the decision of the prosecutor to set the defendant upon this path. So what they're saying is the jury really doesn't, they have the outcome, but the sentencing was set forth by the prosecution based on the aggravating circumstances, which they're challenging that there was no aggravating circumstances to even go forth the death penalty. The consequence of placing no check on the prosecutor's discretion to seek the death penalty is a system in which geography played the largest role in determining whether the accused will possibly be executed. As Justice Breyer found, geography also plays an important role in determining who is sentenced to death. So geography meaning where they're at And that is not simply because some states permit the death penalty while others do not. Rather, within a death penalty state, the imposition of the death penalty heavily depends on the county in which a defendant is tried. So that's what they're trying to do right now, is have that motion to move the case. Some studies indicate that the disparity in charging reflect the decision-making authority, the legal discretion, and ultimately the power of the local prosecutor. So these are just some cases that this has been found to become law. Grand jury requirement of the Fifth Amendment. The Fifth Amendment required that a grand jury pass upon any case involving the death penalty. That right, as Mr. Koberger has argued previously, was intended as a shield against the government to run amok. Motion to dismiss indictment on ground of error in the grand jury instructions or in the alternative to remand for preliminary hearing at page 7, citing ring around the grand jury, informing jurors, and that's, where you can find that at. The origins of adversary criminal trial. It was so revered by the colonists that Madison enshrined it in the Fifth Amendment. And that tells you the history of the Fifth Amendment and the grand jury. Despite this, the Supreme Court in Hurtado versus California determined that the amendment should not apply to the states to the 14th Amendment. The Supreme Court in Hurtado held that the grand jury requirement was simply a choice made by the writers of the federal Constitution and certainly not one required by the due process, if only because the word due process appears in separate clause. So that just gives you some history on that. It talks about the federal grand jury. Okay, then it says, in view of the renewed interest in this intention beyond the jury requirement contained in the Constitution, this court should do what the court in Hurtado chose not to do. Consider the function of the grand jury, how it came to be specifically required in the Fifth Amendment, or whether it was considered a part of due process when the 14th Amendment was adopted. This court will find that the grand jury could not have been replaced by preliminary hearing or the probable cause findings of magistrates, because the grand jury's main function was not the determination of probable cause, but rather its ability to exercise discretion as to which cases were worth pursuing as outlined above. So this is basically talking about the grand jury indictment. And it looks like they're trying to say that the grand jury was like an infringement of Mr. Koberger's rights. I could be wrong. Like I said, I'm not an expert. Usually the individual that has to break these down best that I've ever heard is Jules from Jules of All Trades. It was that channel or whatever it's called. She broke these down. So if you can wait that long, then she'll probably have a better understanding of what this says. I guess it's basically saying the prosecution is the one that is the driving force where death penalty assault. Without this check, the frequency and wanton nature of the death penalty cannot be resolved. Without this check, the nation continues to fail to live up to the promises explicitly listed in the Constitution to provide its citizens from the death penalty. Conclusion: this court must find that permitting the prosecutor to sit in the place of the judge or jury and decide the death should be permissible. Penalty in this matter is unconstitutional. The decision as to whether a matter is in fact a capital be checked in a neutral decision maker. This court should so find and strike the notice pursuant of Idaho Code 19-4004. In this matter, counsel requests the matter be set for hearing, estimated to last 30 minutes. Dated this 4th day of September 2024. So I guess also these are being set forth to kind of give the court a timeline as to how long they want to spend discussing these. And Viviana seems to be a very knowledgeable person, as she is able to decipher court documents really good. Like I said, possibly you could go over there to her channel and she can understand it better than I could. Um, like I said, I wasn't even prepared to really talk about that, but I hope that give you a little bit of insight as how many. I mean, let me show that again. There's a lot of them. So they start right here, motion for the court order, and they go down, motion to strike felony murder aggravator, motion to strike future dangerousness aggravator, motion to strike HAC aggravator, motion to strike multiple victims aggravator, motion to strike notice to intent to seek the death penalty, failure to present aggravators, motion to strike notice of intent to seek the death penalty, vagueness, motion to strike notice of intent to seek the death penalty, contemporary standards of decency, motion to strike notice of intent to seek the death penalty, international law, motion to strike state's notice pursuant to IC 18-404A on grounds of arbitrariness, motion to strike the death penalty, and motion to strike other disregard aggravator. So, those are a lot. Yeah, 12. It's OFFS Viviana. If y'all mods could drop her link in the chat, that'd be awesome. I'm not a paralegal by any means. I'm not any of that. I can tell you that that portion of criminal justice studies is not my forte. I struggled with that like no other. I mean, I don't know if it's the mind that just jumped around all over the place as I'm reading that. I don't know. It's just something that just isn't appealing to me. And I'm sorry if I butchered any of that, guys. I just wanted to show you the documents, and since I don't have anybody in here to really discuss those as they understand it due to their professional um, ability, did the best I could. So 12 new drops. Does that mean that they're looking to eliminate or to push for these motions in the future? Are these some of the did they give them a deadline to be able um to have these in place by this date in order for them to put these on the calendar? I mean, it could be a lot of things. It could be a lot of things. You just never really know the intent on why these were dropped, and so many of them. But I would suggest that maybe you go find somebody that does understand these core documents, and listen to their channel to get the best understanding. Um, okay, here's Viviana's stuff right here. Let me go ahead and play her stuff. That way we can listen to her as she's describing this. Viviana, I hope you don't mind. Let's go ahead and listen to what Viviana has to say about this. Y'all go check out Viviana's page, OFFS. Viviana. Marie01, and it is in the chat. Okay, today was the date to follow any challenges. Okay, thank you, Paula. So let's go ahead and listen to what Viviana had to say.
To challenge the death penalty, and just as we expected she would, she did file those. They just hit the Idaho Cases of Interest website this afternoon. I haven't had time to go through every single document yet, but there is an expert witness disclosure. There are motions to strike all the different aggravators that were used to apply the death penalty, which include utter disregard for life, multiple victims, etc. So I plan on making a video going through the documents when I have more time.
Okay.
Okay, today was the deadline.
So that's exactly what happened. As Paula said, yes, per the scheduling order, today was the date to file any challenges. So that's why there was so much of a drop. Well, I hope you had something yummy. Hey, Heather, yeah, there's a lot in there, man. There's a lot in there. It says defense outdid themselves, only had 4 challenges in her previous case. Massoff had been saying for months these docs were coming. Yeah, so they've probably been, yummy. They've probably been having these prepared, for a while, and they seem to drop everything all at once. So good times, good times. Hey Jeff, you want to come up? Come on, Heather, you want to come up. I want to hear your perception of these documents. I put the link again. Just go ahead and come up. You don't have to show your face, just talk. I want to be the first channel to have Heather Fitzgerald on panel. I want to be the first. Okay, Tara, thank you for that. I know the suppressions are coming. I just didn't know when. They have already scheduled a suppression hearing around February. Okay. Well, I might get off here because I've already been on here an hour and 18 minutes. If you would just give me kind of like a like for attempting to try to read these documents for you and understanding them, I mean, that would be awesome because I have heard your voice. That would be awesome to give me kind of like, a pat on the back for, attempting to get this stuff out there and read it for you and try to understand it. I know I didn't do a proficient job at it, but I tried. I tried. So I hope that you continue to keep coming back to my channel. Like I said, document reading and things like that is not my forte. So I hope you guys find a way to understand those documents. Yeah, and tomorrow is the state's deadline for discovery, so they better get on it tonight. If they don't hand it over, anything that they have, they can't use, So, and like I said earlier, and I wasn't intending to put these pieces together, but let's say the defense has part of a piece that the state has yet to hand over. Well, this other piece that they have, they can't use that either because it connects together. So if they don't turn over the other part, they can't even use the part that they have. So they can't use partial evidence. So I hope you understand that as well. So a lot of the evidence that the defense already might have, if they don't turn over the other half of it, there's a good chance that this other part could be suppressed as well, and not used in the trial. And if that's some of the implicating evidence, then, it's not good for the prosecution. So you guys have a wonderful night. I hope that you can dig this channel, because for some reason that's my new saying. Can you dig it? Let me hear you type that out in the chat if you can dig it. If you're able to enjoy the channel, enjoy the presentation, let me hear you. Let me see you type that out. Let me hear you type that out. And Heather, come on. I want to get you up here eventually. I want to be the first channel to have your own panel. Yeah. Molt. Oh, you know what I always say, right? Maestro, I want you to kill that music. I don't want you to cue it right now, but I want you to kill it. I know you hear this song all the time, but I can't get enough of it, man.
Like you, be strong to hold the powers of the sun. To dream, believe in strength. Now I'm the only one, only one. I was an ordinary boy until I broke the rules. My life destroyed, life destroyed. Until I walk awake, scream my mind, I shout, the ground shakes. How much can I take? My mind will break. Will it break? Can I take? Can I be your superhero?
You guys have an awesome Friday. The weekend's right around the corner. Like I always tell people, you hang in there to the very end, because you just never know when I might start talking again. It's kind of like the gag reels at the end of a comedy. You never know what I'm going to say. It could be anything. But I really do hope you enjoyed it. You new subscribers, thank you so much for your loyalty. And continue to come back, because there's plenty to come. Thank you so much. I'm out.